Welcome to the video series on the McGirt Toolbox. I'm Amy Besaw, and I'm a researcher at the Harvard Project on American Indian Economic Development. The Harvard Project at the Harvard Kennedy School and the Native Nation Center at the University of Oklahoma have collaborated to talk about the implications of the McGirt decision from the Supreme Court of the United States. And today we have with us Carole Goldberg from the University of California, Los Angeles. And she's written a paper on Public Law 280. Carole, would you like to introduce yourself?
Happy to do so, Amy. I'm Carole Goldberg, Distinguished Research Professor of Law at UCLA. And I've been researching and writing about Public Law 280 for almost 50 years. And I suppose the other thing that might be of some interest to folks is that I serve as Chief Justice of the Court of Appeals of the Hualapai Tribe in Arizona. I also served on the Indian Law and Order Commission as one of President Obama's 3 appointees. This was a commission set up by Congress. It was a joint legislative and executive branch commission charged with looking at ways to improve justice and safety in Indian country.
Great. And as part of the colloquium and bringing together these experts to talk about the McGirt decision, one of the pieces that we wanted to talk about was Public Law 280. As I was reading your paper, I'd mentioned to you before that I'd done some background research in Public Law 280 to do honoring nations site visits and going out to visit different programs in Indian country. But I really found your paper to be insightful in different ways that I wasn't expecting, and to really highlight the nuances of Public Law 280. Do you want to give us a quick overview of the Public Law 280 and maybe some of its limitations or difficulties with concurrent jurisdictions?
Absolutely. I think I titled this paper, "The Possibilities and Perils of Public Law 280, a lot of P's in that title. We have to start with the fact that states in general have a very, very limited authority within parts of the United States that are designated Indian country. And Public Law 280 is a law that Congress enacted in the 1950s, definitely part of the termination era, though it was not termination itself. That was different law. But it was designed to be a measure that would put tribes on the road to termination. And the way it did that was by providing authorization from Congress for states to have much more extensive jurisdiction in Indian country than they would normally have. And the idea was to accustom tribes to the laws that are enacted by the states so that when termination came, they would be better prepared for it. Of course, termination was repudiated as a policy during the administration of President Richard Nixon. So many of these tribes that were slated for termination in California and elsewhere did not go forward with termination, but they were stuck with Public Law 280 nonetheless. So Public Law 280 was imposed by Congress initially without the consent of the affected tribes. It named 6 states. Oklahoma was not one of them, that would immediately experience this increase in state jurisdiction, and authorized other states, again, initially without tribal consent, to opt in to this greater state jurisdiction. And some states did so. Again, Oklahoma was not one of them. So Public Law 280 gave a whole bunch of states more authority than they would normally have in Indian country, not unlimited, I might add, but more, and allowed other states to opt in. There was concern from the beginning over the fact that tribes had no say in this. And so in 1968, as part of the Indian Civil Rights Act, Public Law 280 was amended to say that in the future, any state that wanted to opt in could only do so if there was a favorable vote from a majority of the citizens of that tribe. So it was not a decision to be made by tribal governments, but rather by a vote of the tribal citizens themselves, a majority vote.
Has anybody opted in with that?
Guess what? No is the answer. Now, that said, I do want to point out that after 1968, there were a number of congressional acts passed that were settlement acts, land claims that were made under the Non-Intercourse Act, tribal restorations that were achieved through congressional act. And some of the negotiations associated with these federal laws included provisions that the states, Connecticut being one example, would have jurisdiction within the newly recognized Indian country as if they had been part of Public Law 280. So there are some situations, I can't say specifically whether the negotiations were carried out as well as they should have been, but the negotiations surrounding these federal laws did introduce some additional state jurisdiction that is akin to Public Law 280.
And when going through your paper, I really enjoyed the part where you talked about the limitations of Public Law 280 and just sort of how regulatory acts by Native nations don't fall under the purview of Public Law 280.
That is true. It's been one of the most heavily litigated aspects of Public Law 280 because the definition of what is regulatory as opposed to what is criminal, as opposed to what is civil litigation is not a clear line. So there have been lots of cases that have gone up questioning whether various traffic laws of states, for example, constitute regulatory acts versus criminal laws. Indeed, the whole issue of tribal gaming came to the US Supreme Court over the question of whether the state of California's high stakes bingo laws were regulatory and therefore outside of Public Law 280 or criminal and therefore within the state's Public Law 280 jurisdiction. And ultimately, the US Supreme Court said that they were civil regulatory because the state had all kinds of laws, including a state lottery, that allowed for various forms of gaming or gambling.
Right.
And therefore, when the state was putting limits on high stakes bingo, it was regulating conduct that was allowable. It was not engaging in a prohibitory criminal enactment. So this distinction played a big role in the later enactment of the Indian Gaming Regulatory Act.
And I think that leads us into an sort of the meat and potatoes, I think, of your paper, which are the extracting of the information of the interviews that you have done with people who are experiencing Public Law 280 in the various states and the various engagements they have with the states. It's not the same across the board, right?
Absolutely. There are states where cooperative relations between state and local government officials and the tribes have worked out rather well. And where circumstances are not as conducive to tribes assuming a lot of especially criminal jurisdictional responsibility. Other places where there has been tremendous conflict. And this leads me to point out something about how tribes that are in Public Law 280 can get out of it. So the answer is only with great difficulty. Initially, when Public Law 280 was passed, neither the state nor the tribe could initiate a mechanism for getting out of Public Law 280 once they were in. In 1968, Congress enabled states to initiate this process that's called retrocession of getting out of Public Law 280, and a number of states have done so. But it did not create any mechanism for the tribes to take the initiative and to effectuate the removal of Public Law 280 jurisdiction. Indeed, the Indian Law and Order Commission that I served on under President Obama made and I have to emphasize this, unanimous bipartisan recommendation that tribes be given that authority. They currently don't have it. So it's in places where there has been friction between states or local governments and tribes under Public Law 280, the tribes have had to work really, really hard to press the states to take the initiative and get out of it. In Nebraska and Montana, other places, there have been some, big challenges by the tribes, including things like boycotts, to press the legislators to do something about it. In Washington state, where the tribes were able to achieve some political leverage due to the success of gaming and to get some of their own folks into the state legislative halls, they were actually able to get Washington state to pass a law that would grease the wheels to allow for retrocession whenever a tribe wants it. Wow. And one of the things that I've pointed out in the paper that I've written is that now that since 1968, Public Law 280 can only be opted in for a state with tribes' consent through a vote of their tribal citizens. That consent could be conditioned on the states agreeing to proceed with retrocession whenever the tribe requests. And personally, that's what I would recommend if any tribe in Oklahoma wanted to consent to Public Law 280, that they should include in that consent a provision for getting out of it.
And does the McGirt decision influence any of these factors around considering Public Law 280? Are there any implications from the decision itself?
Well, before McGirt, the federal government and the state government were treating the territories that were in question as not being Indian country. So in those territories, the state was just assuming it had jurisdiction as it does anywhere else in the state. Once McGirt is decided and territory that was previously not thought of as Indian country is suddenly declared to be Indian country, then the state is ousted of all of that jurisdiction that it was claiming, with very few exceptions. A crime committed by one non-Indian against another, maybe some so-called victimless crimes committed by non-Indians, they would still be within state jurisdiction within Indian country, but for the most part, the state is out of the business in those areas. If they want to get back in the business, they need to get the consent under Public Law 280, or they need Congress to pass a law, one or the other. But in the absence of that, the tribes are in charge, along with the federal government, the way they are in any non-Public Law 280 jurisdiction.
Well, this is great, Carole. I really appreciate all your time. And if anybody would like to know for more information, please click below to read Carole's paper. Thank you so much, Carole.
My pleasure. Thank you.